Hi, welcome to this video, which is going to be looking at the House of Lords decision in the 2003 case of the Crown and G and Another. The context for the case is that of mens rea, and in particular those situations when the mens rea aspect of an offence can be satisfied by some type of recklessness. Now, the case of G is relatively straightforward from a practitioner's viewpoint, because it sets out the test to be applied in recklessness cases. It could be considered more complicated from a student's viewpoint if you are required to know the law prior to the decision in G. And the reason that this is more complicated is that at that time there were two different tests for recklessness. One was subjective and one was objective, and which one was applied depended on the particular offence under consideration. There is another aspect of the case which is of some academic interest, and that is that it shows when the House of Lords would be prepared to depart from an earlier decision that it had itself reached. And in order for the House of Lords to reach the decision that it does in the case of G, it has to overrule an earlier decision that it made in the case of Crown and Caldwell in 1982. So, before we get to the case itself, what I want to do is just say some more about this context of mens rea, in particular recklessness. Because when we look at recklessness, we're generally thinking about culpability. We're trying to find a reason why somebody should be held criminally responsible for an act that they have committed. There is something about their mental state that means that they should be held in some ways blameworthy for that particular event. And when we look at recklessness, the act involves an aspect of risk-taking. And we often see that the act is a but-for cause of an event, such as the application of force to a person or damage to property. And the question then becomes, should that person that is already a but-for cause become a legal cause of that event, that result, that consequence, and therefore be held criminally liable for that act? And one of the questions we need to ask in that respect is, what degree of foresight, if any, do we require on their part before we convict them? And that's foresight that there was a risk in the act that they were performing and a risk that some consequence might occur. So that's the areas that we're looking at before a person might be considered reckless in a legal sense. If I give you an example, for example, if I throw a stone at someone not intending to hit them, but knowing that there's a risk that I might, am I responsible if the stone hits them? What if I start a small fire near a house, not intending for the house to be burnt down, but because of the risk involved, the house does? Now, what's common in both those cases is that I never intend the result, whether it's the application of force or the damage to the property. But therefore this question therefore arises, should I be responsible for the consequence even though I don't intend it? And if I don't intend it, can I be guilty if I'm reckless? And if I'm reckless, what's the test to be applied? So the offence in G is one of criminal damage, and that is an offence that can be committed intentionally or it can be committed recklessly. Now, if we have a look at the certified question in the case of G, so the point of law of general public importance certified by the Court of Appeal for consideration by the House of Lords was this: can a defendant properly be convicted under Section 1 of the Criminal Damage Act 1971 on the basis that he was reckless as to whether property was destroyed or damaged when he gave no thought to the risk, but by reason of his age and or personal characteristics, the risk would not have been obvious to him even if he had thought about it? Now, on the basis of the law as it stood in 2003, the answer to that question should have been yes, and the conviction should have stood. But as we will see shortly, eventually the House of Lords answered that question in the negative, and the appeal was successful. Now, in terms of the facts in this case, the appellants were two young boys aged 11 and 12, and they entered a yard belonging to a shop. Whilst in the yard, they both set fire to some newspapers and each threw a newspaper under a wheelie bin that was in the yard, and then they left. Now, you and I, as reasonable adults, can see the risk involved there, and that risk indeed did come to fruition, because what happens in this case is that the fire spreads to the nearby shop and causes £1 million worth of damage. So a serious consequence. But at the time, the appellants suggest that they did not foresee the risk that the papers would do what they did. They thought the papers would burn themselves out on the concrete floor. And at their trial and on the appeal, it is accepted that neither of them appreciated there was the risk that the shop would burn, and therefore the question becomes whether they should be considered criminally culpable in those circumstances when they did not foresee the risk. Now, as I've stated, on the basis of the law at the time in Caldwell in 1982, the answer should be yes. But the House of Lords decided to part from that situation. But before we get to that, we need to look at what the law was under the case of Caldwell. And there, the test for recklessness was objective. That is, a person is reckless if the risk of damage would have been obvious to an ordinary, reasonable bystander, and either the defendants themselves recognised the risk, which is not the case for the boys in G, or gave no thought to the possibility of such a risk. And this is the position that the boys find themselves in, and that's why the jury convicted them. And the problem for the boys is that the test for recklessness was, under Caldwell, would a reasonable, ordinary adult perceive that there was a risk? And clearly an adult would. And the law made no allowance for the age or immaturity of the boys involved and their inability to assess the consequences. Now, at trial, the judge did identify to the jury that they might find the law harsh in these circumstances. And it's clear from a question that the jury asked of the judge during their deliberations that they did sense an unfairness in the law that they had to apply, but the judge directed them that they had to apply the law as he stated it, and the jury went on to do that, and they convicted the two boys at their trial. Now, prior to Caldwell, recklessness had been defined in a subjective way, and a key case that illustrates that is the 1957 case of Cunningham. And this required the accused themselves to foresee the risk of a particular type of harm. And indeed, for many such offences, that remained the test even after Caldwell. So for over 20 years, we had these two tests running in tandem, and which one applied depending on the offence being considered. So, for example, if it was criminal damage, the objective test in Caldwell applied, and if it was an offence against the person, the subjective test in Cunningham applied. Now, in the case of G, in short, the House of Lords decided that the test for recklessness should be the same in all cases, and it should be subjective. They concluded that the House of Lords had been wrong in 1982 in the case of Caldwell when they concluded that when the Criminal Damage Act of 1971 was passed, that Parliament intended recklessness to be defined in a new objective way. In fact, in the case of G, the House of Lords, looking back at the law, decided that it had actually been Parliament's intention not to change the definition of recklessness, but to accept the subjective definition of that term as it had been set out in Cunningham, and indeed as it had been set out in a Law Commission report shortly prior to the Criminal Damage Act being enacted. So the difficulty that the House of Lords faced in the case of G, though, was not only was Caldwell a House of Lords case, but its reasoning was then unanimously approved very shortly thereafter in the 1982 case of Lawrence. The objective test thereafter had also been applied in many cases. So it was difficult to consider even overruling the case. But the House of Lords, despite the fact that it was difficult, despite the fact that they would ordinarily be slow to depart from earlier authority that they had arrived at, they did this, and there's a 1966 practice direction that does provide for them doing so. And in particular, in Lord Bingham's judgment, we see that he set out 4 reasons why the House should depart from the decision in Caldwell. Now, the first reason that Lord Bingham sets out was that the court did not regard it as being blameworthy for a person to do something involving risk if that risk was not perceived by that actual defendant. So they supported the subjective form of culpability. Secondly, Lord Bingham indicated that to do otherwise and employ the objective test could lead to unfairness, as happened in the case of G and the 11 and 12-year-old boys. So he recognised there was this sense of unjustness in the objective test, and also reflected on the fact that the jury at the trial had clearly been uncomfortable with what they were being asked to do. And also Lord Bingham said this on this particular point, and I really like this as a quote for supporting the judgment that was reached in the case. Lord Bingham said, "It is neither moral nor just to convict a defendant, least of all a child, on the strength of what someone else would have apprehended, if the defendant himself had no such apprehension." And that seems a fairly clear and fair way of setting out the rationale behind the decision in G. The third reason that Lord Bingham put forward for the House of Lords departing from the decision in Caldwell is that there had been quite a high volume of criticism in relation to the case of Caldwell since it had been decided in 1982, criticism from academics, criticism from other judges, and he said that should no longer be ignored. And the fourth reason he put forward was, of course, if there had been a mistake, it should be corrected, even if it had stood for the period of time that it had. And accordingly, the boys' appeal was successful, and the court went on to set out a test for recklessness, which is as follows, and they specifically tied it to the Criminal Damage Act. So they said, a person acts recklessly within the meaning of Section 1 of the Criminal Damage Act 1971 with respect to 1, a circumstance when he is aware of a risk that it exists or will exist, and 2, a result when he is aware of a risk that it will occur, and it is in the circumstances known to him unreasonable to take that risk. So therefore, there you have a test for recklessness, a subjective test, which means that if the jury had had that test in the case of G, they almost certainly would have acquitted the boys at first instance. Now, there is a separate judgment from Lord Steyne in which he adds to this another reason for allowing the appeal, and that is that he suggests that the application of Caldwell to this case would result in the UK being in breach of its international obligations under the Conventions on the Rights of a Child. So that's an additional factor that he considers to be important. Now, although, as I've just indicated, the House of Lords were only considering a certified question in relation to the Criminal Damage Act in the case of G, it does appear that the tests laid out there and the principles there are now of general application. And for example, if you look at the Attorney General's reference number 3 of 2003, there the court said, the issue as to the proper approach to the concept of recklessness in the criminal law appears to us to have been resolved by the decision of the House of Lords in G. Although the case was concerned with the definition of recklessness in Section 1 of the Criminal Damage Act, general principles were laid down, and therefore the effect of G is not confined just to the Criminal Damage Act, but it's now of wider application. So for offences that can be committed recklessly, a subjective test should be applied. So that's the case of G. It was for me one of the most unexpected but welcome of cases. At the time, I didn't expect the House of Lords to overrule Caldwell, but I'm glad that they did. Overnight, it simplified the law. It made it fairer for those that were making decisions whether to prosecute, as I was at the time, and it also made it easier for juries in their decisions as to whether to convict people, particularly people whose characteristic made it difficult for them to perceive risks that a reasonable ordinary adult might, such as in the case of G. Now, there is a potential downside to G, and that is, of course, in G there was £1 million worth of damage caused, and it was definitely caused by these two boys. In my earlier example of throwing the stone not intending to hit someone, if the stone hits, that might cause injury. And in cases like that, the downside is that the victims concerned may feel unsupported by the criminal law and the legal system. But that is the case of G.